Good morning, everybody. Hello. Welcome to my webinar this morning. My name is Amanda Chadwick and I'm a senior speaker at Peninsula Business Services Limited. Today we're dealing with and talking about disciplinary issues, appeal meetings and grievances. It's going to be quite an in-depth webinar. But as I say, it's all my webinars. Don't worry. These slides you can have later on. They'll be posted onto YouTube along with the recording, so they'll be available there. And at the end of this webinar, I'll show you a slide with a link to YouTube, and also if you want to contact me directly, I'll put my email details up there as well, and it will be me that responds to you, so don't worry about that. First of all, I think whenever, if you've heard my webinars before, you know that I'm a speaker on employment law and health and safety. I do speak for most of the associations and federations throughout the UK. I also do mediation work, and there's a lot of things that I've learned from mediation, and quite a bit of it can be sorted out right at the very, very beginning if you get it right, going back to the nitty-gritty at the very start and getting it right by speaking to your staff. And you should have many opportunities to do that, hopefully. And we'll talk about this, because at the end of the day, we're all human, and it's really, really stressful to have a tribunal. It's also very stressful to have to put up with a tribunal if an employee is saying things about you. And also we've got the tribunal reforms now, and I'll just make it very, very simple for you. The tribunal reforms have been brought in to the charging system, really, to bring it in line with the court service, because it's one area where there's not a penalty. And there's two types. There's an A and B claim, and really what it is, for the employee, this is what it means. If I think I've got a grievance against my employer and I want to take them to tribunal, I have to pay a fee to have the case heard, and then I pay a further fee when it's being heard. So it's going to cost me, okay? So that's a simple, cut and dried version of it. This is the bit that's the important part for the employer, is if you get it wrong. So if you get anything wrong, and that might be just down to a procedure, just down to a simple thing, and it's found, it's found in favour of the employee, what happens is you have to pay those court fees. So that's the penalty to the employer. So quite simply, to the employee, if I want my case heard, is it in band A or is it in band B? And that's the fee I pay to get it, to initially register it, and then to get it heard as well. So there's a fee for me, the employee. If the employer is found guilty, they pay the fees, okay? So it's as simple as that. So when people talk about the charge system, just think of it like that. So we've got to get these disciplinary issues right. We've got to get grievance procedures right. We've got to hear the appeal hearings in the right way. So we're going to talk about that now. So that's the tribunal charging system. And this is the first slide. So, and by the way, I don't particularly like having my picture taken, so if you want to put that up in your garden to scare burglars off, feel free to do that. So the top 10 things to have in place. 1, written statement of main terms. I speak about this all the time, okay? This is your start. This is, if you're wondering what the statement of main terms is, I'm sorry if I'm going back to basics for some people here, but I need to do this because there is a change that you need to be aware of that's going to happen to the main statement of main terms. The statement of main terms is when I'm sat with you at an interview, I'm asking you, where am I working, how much am I getting paid, what hours am I doing, what's the employer's address, that type of thing goes in the statement of main terms. The change that is happening to the statement of main terms, and you need to know this, is the Pension Act, okay? Check your staging date on the government's website. On there, it tells you that you have to include on the statement of main terms who the pension provider is. Okay, how many of you knew that? So whoever the pension provider is, you know, that's got to go on the statement of main terms. So that means that I would say most of your statement of main terms that you have within your business at the moment will need to be changed because of the Pension Act, okay? So that's the first thing, statement of main terms. That's my personal contractual terms with you. It can be different for different people within your business. So that's the first thing. Why do I mention this here? It's because if you do it, you get everything wrong that I'm about to talk about, and you end up in a tribunal, guess what? There's a penalty. If you haven't issued a written statement of main terms, then there's a penalty. And the average penalty, this is above any other payout, is £1,400. So get writing. Okay, so the second thing that I recommend is a job description. I can't write KPIs, I can't write appraisal systems, I can't manage one-to-ones without a job description as a benchmark to know exactly what you're supposed to be doing. So a job description, I would want that written when you're about to advertise a job so people know what the job entails and what the roles are. Okay, if you want to add a personal specification to that, which is not about the job but about the person you're looking for, that's fine. But a job description tells you about the job. Use that as benchmarks when you're writing KPIs and staff appraisal systems. So, okay, the standards and expectations of the business, the conditions, okay? This is where, for example, I run a hairdresser, I've advertised a job, this man's coming in to work as a barber, and I've given him his statement of main terms. On day one, when he joins my company, I give him the rules. These are the rules. These are my standards and expectations. This is the handbook, yeah? In there, it tells you how long your probationary period is, tells you how you should take your holidays, it tells you all the rules about my business, but guess what? It legally contains the disciplinary rules and procedures and the written grievance rules and procedures and the appeal rules, okay? That's in there as well. Legally, I have to have that in there. So that's what the rules are. And that handbook, only 90% of that is things that you've put in there, you know, what you consider to be your rules. They're not the law, and they have to be reasonable, okay? About 10% is the law. So the handbook is your rules. You want the job with me, these are the rules for working for me, okay? And when they join your company, they accept your rules. I also like to see in the handbook, as I said, the written disciplinary rules and procedures, which we're about to talk about, the written grievance rules and procedures, which we're about to talk about, and also the capability policies and procedures that we won't be talking about today, but I'll try and I'll find some time to do that. We did speak about it yesterday. What I'd also like to see is KPIs and appraisal systems in use within your business, because you could use those as disciplinary evidence if somebody isn't doing the job that they should be doing. And it might be a conduct issue, which is where they can't be bothered doing the job, but it might be because they, you know, or it might be a capability issue where they can't do the job, and it might be because of lack of dexterity, health reasons, and something like that, okay? But it could be also training, but we can only find that out with KPIs and appraisal systems in place. Brilliant tool to have if you're speaking to people about the way they are, but also to get buy-in off your staff as well. So create a paper trail. Use the formal documentation that I always talk about, from the application form, the induction form, to training documents, to pieces of paper where you speak to your staff, to holiday request forms, etc. This is your paper trail, because this is what you're going to use when you're speaking to somebody at an investigation, a disciplinary, because this is your evidence gathering, okay? And then obviously top 10 things to have in place is to train your managers and your employees and educate them what is right, what is wrong within the workplace, what they should be doing and shouldn't be doing. And it's up to you to keep a record of that training and get them to sign to say they understand the training they've had, the education that they've had, they understand the policies and the procedures. Understand for me legally and tribunal is a winning word. So keep up to date with employment law changes as well. That's not a bad thing to do, is it really? And if you're a client, we get lots of telephone calls on advice line when they go, have I missed something? So, you know, just keep up to date with employment law changes. So, okay, things to remember before taking action. So this is if you find yourself in a situation where you're going to have to do an investigation, or you're about to enter into a disciplinary or an appeal hearing or grievance hearing or even harassment claim. Things to remember before taking action. You know what? Remain in control. Don't feel intimidated by somebody. Remain in control of the situation. Remain calm, no matter how angry you are, okay? Just remain calm. Don't overtalk the person. Listen to them. And be consistent when you are making decisions. Don't just think that they're guilty straight away. They could be innocent, so remain neutral. We've had plenty of cases where they've looked guilty straight away, but actually they've been innocent at the end. Investigate thoroughly, and remember that your staff are not mind readers. Make sure written rules are in place. So no mind reading here. Don't think that they should know the rules. They should be written down, because this will be challenged if you end up with a tribunal, okay? And there are areas of that will be challenged in tribunal, such as consistency, such as you thinking they're guilty but actually they were innocent and you didn't remain neutral. Also, not investigating it thoroughly will be challenged at tribunal. If somebody screamed at you to look at CCTV, you know what? Look at CCTV. And remember, they will say to you at tribunal, your staff are not mind readers, okay? So how did they know they were going to get disciplined for that if you haven't got it written down, okay? So make sure the written rules are in place. So let's start with the process and the investigation, and we'll start with step 1. The first thing is you need to investigate the facts. Somebody's saying something's happened, you need to invest the facts. You need to do this without delay, okay? So don't wait until you're finished doing your stock taking. Don't wait until the end of the day. You need to do it straight away. Investigate even if the employee seems guilty. So I'm going to give you 2 examples here. So I'll give you one example here because we've got a few slides to go through, and it's the example I always give out when I'm talking about investigation. Okay, and the first one is it's a business, it's a company that handles security. Okay, and if you've heard my webinars before, you'd have heard this example of where we really are innocent until proven guilty. However, in a tribunal, we've got a reverse burden here. As an employee, I can say what I want about you, and I am innocent until you're not guilty. Sorry, start again. As an employee, I can say whatever I want to against the employer, and you are guilty until you prove yourself innocent. So if I'm saying that you didn't investigate it thoroughly, you've got to prove that you did, okay? So it's a reverse burden of proof. In an ordinary courtroom, I've murdered my husband, you've got to prove that I did it, okay? And I'm innocent until you prove it. So an employee can say what they want. So here we've got as an employee who works as a security guard. The place where he works, he's put there, so that it's not the company he works for, he's placed there by a security contractor. Where he works in a lodge within the car park area, and also there's main buildings as well. In the main buildings, there is a cupboard which houses lots of stock such as coffee, tea, sugar, stationery, pens, that type of stuff. And the security guard is seen leaving the lodge, okay? There's no CCTV footage in the lodge, but there is in the car park. And what happens is the CCTV picks up the security guard going across the car park from the lodge to the main building with a black carrier bag. You know what I'm talking about. And he's seen then on the CCTV inside the building, opening the stock cupboard and filling it up, okay, with lots of stock. He's seen then again locking the cupboard, walking across the car park, and then obviously the CCTV footage does not show him inside the lodge. Several hours later, at the end of his shift, he's seen coming out of the cabin with the black bag and then putting it into the boot of his car. He's then seen driving off. Next day, the security company gets a phone call from their client to say that there's lots of stock missing and that the security guard is seen on CCTV camera in the building emptying the stock cupboard. Okay, so it looks guilty, doesn't it? He looks guilty. He's driven away with a black bin bag full of stuff. It's out of the cupboard and they can't find it. So at the end of the day, it looks like he's guilty. Let's do a thorough investigation here. When the man was questioned, and remember it can be informal at first, when he's questioned he says, I understand what you're saying, it does seem that I am guilty, okay? You've got the CCTV evidence of me going to the stock cupboard, you've got me filling the bag, you've got me, putting it in the boot of my car, but you're missing something out here. You can't see what's happening inside the lodge cabin, yeah? You can't see the fact that, yes, I did walk across the car park. Yes, I took the black bin bag into the lodge. What you can't see is me emptying it and putting all the stuff in the cupboards and around the lodge, because what you also don't know is that was my last shift at those premises and you've moved me to another premises. And they said, oh gosh, yes, we forgot about that. Yes, but what I'm doing is emptying the black bin bag, restocking all the lodge for the new security guard that's coming in, and what you can't see is me then putting my own boots, my radio, my magazines and books into the black bin bag and then putting it in the boot of my car and driving off. And in fact, if you come with me now, I'll take you to my vehicle and show you the said black bin bag that we're talking about. And they could have only done that, by the way, with a search policy in place, but they went to the back of the car, they opened the black bin bag, and yes, he was telling the truth. And when they checked the lodge with their client, they could see that all the stock could be accounted for and he hadn't stolen it. So investigate even if the employee seems guilty, because quite often they're not. Investigate thoroughly to ensure that you get the true facts in place and that the substance of the allegations are clear, and document it. Remember, no statutory right to be accompanied at this stage if you're speaking to somebody, but consider whether to allow employees at this stage if they request it, and also consider the age of that person. So you might be dealing with a young worker that might feel really intimidated by having an investigation. No formal disciplinary action should be considered at the investigation stage, and try and make sure that the investigating manager is different, if you can, more junior than the manager who would be hearing any subsequent disciplinary hearings. So step 2 of the process of the investigation is to remember the ACAS code here. It encourages informal resolution. Consider whether you are proceeding in a formal manner or an informal manner, and still keep notes if dealing in an informal manner. Make employees aware that if further instances, misconduct and poor performance occur, you may take the formal route. So that's step 2 of the investigation. And then we come to step 3. At this stage, you have to consider suspension. Now, I want to stop for a second here. We've dealt with several cases of fighting within the workplace, and it may be that you think you've got a troublemaker within the workplace, and they're involved with a fight. So what we've noticed that some employers do is they suspend who they think is the troublemaker and keep the other person at work. You've made a mistake straight away. You should suspend both parties. So consider suspension. Any suspension should be kept as brief as possible, both for the employee and the employer, because they're suspended on full pay. So we've got to reduce the suspension costs. Review the suspension regularly. The terms and reasons for the suspension should be communicated verbally to the employee at the time of the suspension and then confirmed in writing as soon as possible. Normally, unless the contract states otherwise, during any suspension, an employee should continue to receive full pay and benefits. Let me stop for a second. This is where we get the more complex issues sometimes with the industries such as teaching, nurseries, the police, the fire. They suspend people, and it can be a lengthy investigation. What you do find is that it then hits the newspapers, and it says things like police officer suspended on full pay with benefits for 6 months while taxpayers pay it. The penalty for getting it wrong, you see, is more costly than suspending them for 6 months. That's why there's got to be a full investigation. Inform employees who their point of contact is during the suspension period. There is nothing worse than being suspended from work on full pay and not knowing who you should be ringing up if there's an issue, or wondering when you're coming back or how the suspension is going. So make sure there is a point of contact. Just because an employee is suspended doesn't mean to say that disciplinary action will be taken or that any matter has been predetermined. Reassure the employee of this. Step 4, the process is the disciplinary process. What you're doing here is you're informing the employee in writing of allegations and invite to a meeting. Make sure that you have written and set out with sufficient information the allegations and possible level of disciplinary sanction. This will enable the employee to prepare their side. Include documentation and evidence that will be used or relied on in the meeting. Inform the employee they have the right to be accompanied, and this should be written into your handbook to say a fellow employee or trade union representative. What you don't want is their 22-stone partner who's a bodybuilder, who's very, I'm not saying all bodybuilders are aggressive, apologies there, but, you know, a 22-stone hard person turning up and going, how dare you talk to my partner like that? My husband, my wife, my son, my daughter, my cousin, you know, so let's make it perfectly clear here, fellow employee or trade union representative. Meetings should be convened at a reasonable time and place. This is the same actions really you would take with sickness, reasonable time and place. Meetings should be within normal working hours. Provide reasonable notice that you are giving the employee time to prepare. If the matter is sensitive or of a confidential nature, which quite often happens, it may be advisable to hold the meeting elsewhere. If the employee asks for postponement, consider this request. And then we've got the process again and disciplinary. It's continued here. We've got step 5, which is holding the disciplinary hearing. What I would want you to do is set the scene. Check that the employee is comfortable with the arrangements made and that they have received all the documentation. Explain the charges against the employee and explain and go through the evidence that you have. Give the employee a chance to ask questions. And remember, don't overtalk and listen. Present the evidence and call any relevant witnesses that you've got. Prior to closing the hearing, check with the employee whether they have anything further they would like to add or say in their defence. Summarise the meeting and then adjourn to consider any follow-up or decision. If possible at this point, as the employee asks, there's a K missing off the end of that, ask the employee to read and sign the notes of the meeting, to agree to the accuracy and to provide comments. You might take time out to do this. So we've got a few tips here just for the disciplinary hearing alone. Approach the hearing bearing in mind that the last thing you want is you want an employment tribunal. You want to avoid this, okay? And you don't want your tribunal hearing resulting from this process at all. Remember, you are the chair. Let the employee present their response to the alleged matters of concern. It's a really good idea to have a note taker present in the disciplinary hearing because it's very, very difficult. It can get heated. Somebody can get upset. You're keeping notes. So make sure you have a note taker there present in the disciplinary hearing. Both parties should ultimately agree the notes of the disciplinary hearing. The focus of the disciplinary hearing should be on the matter of concern. And be aware of tactics. The employee may attempt to divert and deflect away from the reason for the hearing. So, tips again for the disciplinary hearing stage. The decision or outcome don't appear to make it or advise in the disciplinary hearing, as this will appear as no consideration or reflection has taken place with regard to what the employee has stated in the disciplinary hearing. Advise of the outcome or the decision in person in writing. Issue appropriate level of warning or dismissal should be in line with your disciplinary procedures. Because what we've got to remember here is that one disciplinary might be different in one organisation to another. And that's why I always say you shouldn't copy somebody else's contracts. Because you could be copying a company that has nothing in common with you. And they have different lines of procedures and different levels of warnings. Provide right of appeal against a level of warning and dismissal. And remember, normally and ideally, a different individual should hold each stage of your disciplinary situation, i.e. the investigation, the disciplinary hearing and the appeal. So the next stage of this is the appeal process. This is step 6. This is informing the employee in writing of a decision and offer of appeal. Whenever you have a decision, you should always offer the appeal as well. You have the right to appeal against this decision. Any decision should only be made after the disciplinary hearing has ended. You can inform the employee verbally of your decision after a short adjournment. You have to inform the employee in writing of any decision as soon as possible after the hearing. The decision letter must set out sufficient details of any reasons for any decision to impose formal disciplinary sanctions. The decision letter must contain the right of appeal. The deadline date for the appeal to be submitted, recommended by ACAST, is 5 working days. Remember, that's 5 working days. Not, don't include weekends, it's 5 working days. So then we've got step 7. Again, still the appeal. And if the employee appeals, this is what happens. Send written invitation to attend the appeal hearing. Excuse me. Employees have the right to appeal. Remember that. Don't feel offended. Employees should let you know the grounds for their appeal in writing. You can ask them to set out full details of the grounds prior to the appeal hearing. If possible, the appeal hearing should be dealt with by a manager who has not previously been involved in the process. If possible, try and use a more senior person than the person who made the original decision. Send employee a written invite to attend the appeal hearing. Written invite should set out the proposed arrangements for the appeal hearing, contain the identity of the appeal manager as well, and should also inform the employee they have the right to be accompanied again, as I said earlier, with a trade union official or fellow employee. The appeal meeting should be held at a reasonable time, place and during work hours, and consider any requests for postponement. So now we've got step 8, which is holding the appeal hearing. So the appeal manager should have had any access to the evidence compiled during all procedures. That means the investigation and the initial disciplinary stage. And I'm not on about half an hour before the appeal meeting. They should have had it well before this to consider it, to look at and weigh up any mistakes. Excuse me. Somebody who's not been involved in this process before will have a clear head and can see any mistakes or evidence in a new light. Okay? It's amazing how many people can be involved in an investigation disciplinary and still maybe get it wrong. So it's a really good idea, as I said, to give them plenty of time to analyse the evidence that's set out in front of them. The appeal manager should not confer with the initial decision maker prior to the appeal. It is possible that any procedural defects in an initial disciplinary hearing may be corrected on appeal, if the appeal hearing is sufficiently comprehensive. Set the scene again by asking, is the employee comfortable, has had all the documents and happy with the arrangements made? And that's really a tick list for you. Listen and give employee a reasonable opportunity to present their grounds for appeal. Listen, call relevant witnesses, and prior to the closing of the meeting, check if the employee has anything further to add. Sum up the meeting and adjourn to consider any follow-up action or decision. If possible, ask the employee to read and sign the notes of the appeal hearing as accurate, and also if want to provide comments. So now we've got step 9, and this is informing the employee of your final decision. This should be in writing, decision made after the appeal hearing, so don't make it before. Can inform employee in first instance verbally, only after short adjournment. Employees should be informed in writing of the result of the appeal hearing decision as soon as possible after the appeal process has ended. In cases where there is a dismissal has been overturned, consider the level of support of facilitating return to the work. So this is what, if somebody's gone through all this, which can be exhausting, it can hit them hard, and actually they've won their appeal. You really need to consider the level of support of facilitating their return to work, because it can go against you. If the employee is not successful in their appeal, the letter must contain the decision and set out the reasons why the appeal was not upheld. So now we're going on to grievance procedures. These are put in place so that if an employee feels dissatisfied with any matter in relation to employment, there is effective ways and procedures for grievances to be heard and, where appropriate, resolved. So that this is a legal requirement to have in your handbook. This is where somebody's unhappy about something in work. It's where, prior to going back in 2004, when the statutory dispute resolution procedure came in, which is now known as the Code of Practice, what was happening is people tried to handle sort of like issues within the workplace, and then it was decided there should be set procedures to follow. And one of the guidelines set down by the tribunal services was that it's a really good idea to have a grievance procedure in place, because that gives the employer an opportunity to hear people that are complaining about stuff and to take it seriously. So that's why there is a written grievance procedure. What these procedures are there for is to really prevent tribunals. So we're going to investigate and speak to people, because prior to this act coming in, what would happen is an employer would just go, "You're sacked, that's it, get out." And they maybe would think that they're guilty, and they might not be. There was no investigation, there was no appeal if somebody felt they were treated incorrectly at a disciplinary hearing, or the investigation wasn't held correctly. There weren't any grievance procedures, and so the tribunals ruled that they had to be in place, because a lot of the tribunals that were being heard didn't need to be heard. A lot of the situations could have been sorted out well before a tribunal and saved the employer and the employee time and also money. So that's why you've got the grievance procedures, that's why you've got the disciplinary procedures, that's why you've got the investigation, and you've got the appeal procedure to give you every opportunity to exhaust any avenue before it goes to a tribunal. So put in place the grievance procedures, and remember, they can be informal without written record. Formal grievances really should be in writing. Informal doesn't have to be in writing. But if we're looking at personal harassment or bullying, there should be a separate policy for this. And in the personal harassment policy and the bullying policy, we talk about confidential helpers. This is somebody that's seen that supports the member of staff if they're going through a personal harassment claim. It's somebody that will help them letter write and approach individuals. So that's what we would call a confidential helper, if you've never heard of that before. So remember, we can start this process. The employee or the employer can start this as an informal process without any written record. Formal grievances should be in writing though, and personal harassment is separate. Any grievances should be raised to the person specified in the statement of main terms. That name of the person should be in the statement of main terms. We spoke about that earlier on, remember, that piece of paper, the initial one you give somebody when you offer them the job. Invite the staff member to the grievance hearing. Oh, I spelled that wrong, haven't I? Sorry, I'll correct that one before I put it on YouTube. Look, there's loads of different words today that you never heard, like YouTube and herring. So I do apologise about that. It's a new language I'm creating. So invite staff members to the grievance hearing. Apply same rules, reasonable time and location. Investigate fully, as before. And remember the top tips I've given you on that. Listen, look at things, etc. And speak to witnesses. Notify within 10 working days. Include the right of appeal. And the appeal must be in writing within 5 working days. Invite to meeting with the same steps and more senior managers where possible to hold. Again, inform a decision in writing within 10 working days. I think once you start getting into the habit of doing investigations, disciplinaries, and appeals, a grievance hearing, so it's the same sort of process, but always remember the same basic rules. Listen, document, paper trail, reasonable times, locations, investigate fully, and always remember the notification time scales, because if you get this wrong, any element of this wrong, it will be pulled up in tribunal and you may find the case ruled against you. Just based, if you ever speak to somebody who's had a tribunal and they've lost, they'll go, it was down to procedures. I did everything right, but it was procedures. So you've got to get the procedures right. They're there for a reason. So, the foundations for you to remember: have in place a disciplinary policy and procedure that is in line with the ACAS code. We've all got mates that are solicitors or lawyers or barristers, haven't you? Or HR professionals. You ring them up and you say, you couldn't give me a hand on this, could you? Remember, they might be talking about the rules they've got written down in place within their company. If you are speaking to a solicitor, make sure they don't just deal with conveyancing or family law, because it's a totally different law, I'm telling you. We deal with this, and I deal with employment law and health and safety every single day, 24/7. You've got to have somebody that deals with it that's 100% dedicated, because law changes all the time. So have in place a disciplinary policy and procedure that's in line with the ACAS code. Refer to your own disciplinary procedures that are in place. Don't breach your own contracts. Make sure your employees are aware of the procedure and what misconduct is. No surprises there, they're not mind readers. Fact. Be careful of assumption. Sack an employee based on assumption and you might end up in an employment tribunal. Let the facts speak for themselves. And that old saying where you listen and don't say anything, you get a lot of information out of people, believe you me. Aim to be fair, consistent and reasonable in the application of the disciplinary procedure, and this will help to avoid employment tribunals. Follow your own processes, not somebody else's. And always, I always say this to clients of ours, don't write your contracts in the independence language. Write it in the Sun's language. Use balance and neutral language that everybody understands. Remain calm and in control. Sometimes you might want to feel like hitting somebody, but don't. Use a stress ball, okay? So remain calm and in control. You may be angry, but remember, don't prejudge or preconsider. Consider and reflect. So I've got a list here of our examples of misconduct, so I'm going to read them out to you. There's much more than on there. That was just an example on that slide. But ensure the disciplinary policy and procedures include examples of misconduct. Examples of misconduct, okay? I'm going to read out this list, okay? And it says here, this is rules covering unsatisfactory conduct and misconduct. These are examples only and not an exhaustive list. You will be liable to disciplinary action if you are found to have acted in any of the following ways. And I'm just going to go through a few examples for you. Failure to abide by the general health and safety rules and procedures. So make sure you've got general health and safety rules and procedures. There's a good idea, isn't it? Okay, saying what they can and what they can't do. Smoking is at designated non-smoking areas. So it's good to have a smoking policy and a non-smoking policy and what the designated areas are. Possession of alcohol on the premises, okay? Might be a good idea to put that in there. Persistent absenteeism, and a search policy, by the way, because sometimes people, I can think of so many cases where alcohol's been disguised as Lucasade, for example, or a bottle of orange. So possession of alcohol on the premises, you could only check that it's alcohol, couldn't you, if you had a search policy. So maybe consider having a search policy. Persistent absenteeism or lateness. So what about a lateness policy and a sickness policy to coordinate with this? Unsatisfactory standards or output of work. You'll only know it's unsatisfactory standards of output of work if you've got key performance indicators and appraisal system in place. And a job description. Unauthorized use of email and internet policy. This is something you need to keep on top of this. Emails, internet policies, social networking policies saying, you can't have my clients as friends on Facebook. Things such as you can't, saying that, I don't mind you saying that you work in the law industry, but you can't actually say who your employer is because I've seen what you get up to at the weekend. So making sure that, your email and internet policies are all up to date. Rudeness towards clients, members of the public, management or fellow employees, including objectionable or insulting behaviour, harassment, bullying or bad language. Failure to devote the whole of your time, attention and abilities to our business and its affairs during normal working hours. So I would say if they're using Facebook in work, we've covered 2 there, haven't we? Failure to carry out all reasonable instructions or follow our rules and procedures. Unauthorised use or negligent damage or loss of our property. So it's a very good idea here to have a wastage policy. So such as things as, negligent damage or loss of property could be somebody who's deliberately damaging your vehicles, your cars, losing the shutter keys, that type of thing, but repeatedly. So not only do you have a wastage policy that claims back the money, but also at the same time you've got a disciplinary procedure in place as well. Failure to immediately report damage to property or premises. So knowing something's broken can cause a health and safety accident, can't it? Use of our vehicles without approval, failure to report any incident whilst driving our vehicles, whether or not personal injury or vehicle damage occurs. If your work involves driving, failure to report immediately any type of driving conviction or summons which may lead to your conviction, and loss of driving licence where driving on public roads forms an essential part of the duties of the post. Well, that is just basic unsatisfactory conduct and misconduct. But then we've got serious misconduct. This is gross misconduct, and I have to say to you that is actually there's not, it's rare really that you would actually go straight to gross misconduct, but I'm going to give you a list in a moment. So it's where one of the unsatisfactory conduct or misconduct rules have been broken, and if upon investigation it is shown to be, and this can happen, to be due to your extreme carelessness or has a serious or substantial effect upon our reputation or operation, they may be issued with a final written warning in the first instance. You may receive a final written warning as the first course of action if an alleged gross misconduct disciplinary matter upon investigation is shown to have some level of mitigation and is treated as an offence short of dismissal, or just short of dismissal. Failure to comply with the company's smoking rules also falls into the category of serious misconduct. As such, it is repeated here, okay? Smoking is only permitted in your own time, i.e. before you start work, during your contractual lunch break, and after you finish work. This is, for example, this is a sample policy. You might say during your break as well. If you are found smoking during your working hours, this will be deemed serious misconduct and you will be issued with a final written warning. You will also have your leave entitlement reduced by 2.5 days. This is for our policy, so I'm giving you an overview here today, okay? This is something that we've written down, but I'm giving you an example of how that would be used. So remember, you might not have this or part-time equivalent. If you're found smoking during your working hours a second time, this will be deemed a breach of the first or final warning and result in dismissal. That just gives you an example of our serious misconduct. But then what I'm going to do is I'm going to give you rules covering gross misconduct. And this list is examples only and not an exhaustive list. Okay? So, you will be liable to summary dismissal if you are found to have acted in any of the following ways: grossly indecent or immoral behaviour, deliberate acts of discrimination or serious acts of harassment, dangerous behaviour, fighting or physical assault, incapacity at work or poor performance caused by intoxicants or drugs, selling, possession or use of illicit drugs during or outside of working hours, with evidence you can tie that into, obviously, social networking, can't you? So it really goes down to what people put down, what they're doing in the outside hours. You'll be very careful of this and what you've got written down. Invasion of privacy, but there's a fine line here where we can use it. Deliberate falsification of any records, including timesheets, absence records, and so on, in respect of yourself or any fellow employees. Now I'm going to stop here. If you find that's happening, you need to deal with that immediately, because if you don't, you could be tolerating somebody's intolerable behaviour, and then you're going to have a problem with gross misconduct. So you've got to deal with that straight away. So don't let somebody off. Undertaking private work on the premises and or in working hours without express permission. Working in competition against us. Taking part in activities which result in adverse publicity to ourselves or which cause us to lose faith in your integrity. Theft or unauthorized possession of money or property, whether belonging to us, another employee, or a third party. Destruction, sabotage of our property or any property on the premises. Serious breaches of the health and safety rules, including those within the Employee Safety Handbook, which endanger the lives of employees or any other person. Interference with or misuse of any equipment for use at work that may cause harm. And then it goes on, gross insubordination and or continuing refusal to carry out legitimate instructions, abuse of the personal harassment policy, and abuse of the protected disclosure provisions. And then what I would expect to see really beyond that is the disciplinary procedures and what would, the offence, what would happen on the first occasion, second occasion, third occasion. That's what I would expect to be written. I'd also expect an element of something saying we retain discretion in respect to the disciplinary procedures with people that are here on shorter service. And that's really basically what I would look for examples. So what we've done recently is, you will notice if you're our client, you're seeing a lot of the services that are available to you that we've now got. We've got the HR Online, which is a fantastic cloud-based system that stores all your documents and your policies and procedures securely online, and it's absolutely brilliant. Monitors sickness and absence, just one of the tools that we've got. There's nothing quite like it on the market. We've also introduced, we've got an employee assistance program now that we've designed as well for our clients. But you see, what we're listening to is we're listening to our clients and also non-clients as well. And we're getting a lot of people approaching us because of our experience. We've been established since 1983, and we integrate ourselves within 26,000 companies throughout the UK. But after spending time listening to our clients, we've designed a special service for those clients who require special on-site help, because it can be intimidating sometimes to deal with any of the issues I've spoken about. Sometimes it's easier to bring the experts on site than try to struggle with more complex issues than usual. The issues I might be talking about, I am talking about, not might be, would be such things as investigations, disciplinaries, disciplinary appeals, a 2P for certain, because that's such a complex document. I always need hand-in-hand guidance, even though I'm an expert, and just check that I'm doing the right thing all the time with that, because 2P is so complicated now, and redundancy consultations and layoffs. So what we brought into the Peninsula band of benefits that we have is we've got an on-site tool called HR Face-to-Face. You can upgrade to this and you can have it as an additional benefit if you're a Peninsula client. If you're not a Peninsula client, you can actually subscribe to it just for a daily rate. This can include coaching, mentoring prior to the meeting on the day. It's on-site support, site support, and attendance at meetings such as the list I've given you. Holding and conducting meetings for your business such as investigations, grievance appeals, because some businesses don't have the staff in to be able to offer somebody in each individual meeting. All the travel and related costs are included in the per day cost. Production and drafting of any documentation related to the meeting at the face-to-face consultant has to attend or hold, chair or support assist at. Owning the issue for directors and managers within your business so confidence can be instilled and support provided in difficult or complex employment situations. So that's just another tool that we at Peninsula have invented and produced for our clients and non-clients, because we've listened to you. We have a steady, regular package. that we brought in we've always had in to support businesses, but we've got more and more businesses now going, could you please come to our premises and help us with this, because it's just a bit too complex for us. So that's why we brought in HR face-to-face. You know, sometimes it does take that. It takes somebody going down to the site. And remember, when I'm talking to you, we are still a family-run firm, Peninsula. I know we've been going since 1983, but we're a family-run firm that's based off a tribunal, based from a tribunal where our boss had a tribunal because he sacked somebody on the spot who stole money from him. And then he ended up with a tribunal where he didn't understand the system, he got everything wrong and he lost out. And that's how Peninsula started. And I'm not sure if you know that, but that's how it started. And it's a family-run firm still to this day. We support people. So today I'd like to thank you for listening to me. What I have got here is 3 links now. I've got the one at the top where it says www.youtube.com/PBS Press Office. That is my link for YouTube for any previous webinars that I've held, and the one today. This is going to be on there later on though, so don't expect it to be there yet, okay? I'm not that quick. And what we've got here is we've got 2 other links. Now, you heard me mention at the beginning about the change to the State and the Main Terms and the Pensions Act. There's also changes that need to go into your handbook, and also you need to know what your workforce status is. I'm holding face-to-face seminars that are free, don't cost you anything, throughout the UK. I'm also getting a pensions expert to come in with me, and I'm not picking somebody that bores me. I'm picking somebody that actually speaks to people like I do, so you understand. Because I'm not a great listener anyway. I like people to just speak sport. See, I told you I'd introduced lots of different language today. That's a good word, isn't it, sport? But to speak to people in everyday language, you know, so that you sit there and go, is that how simple it is? So what we've got is this link here. It's free at peninsula-uk.com. That is what you use if you want to contact me to be invited to a pensions seminar, and if you want to go to any of my seminars that I hold that aren't pensions anyway, you can come to one of those. Or if you want some free advice and you're not a Peninsula client, or you want a free consultation and you want to know what we do, that is where you contact me, free at peninsula-uk.com. And I can assure you, when you get an email back off me, it is off me. It's not from somebody else typing, okay? So the other email I've given you is Amanda at peninsula-uk.com. That email is if you've listened to me and you think, do you know what, I wouldn't mind holding my own event for my clients. We will hold that event for you for free. It won't cost you a penny. If that's something you fancy, you want to hold an event for your clients, it can be any subject you want, or just an overview on everything, or updates, or you would like to host a webinar for your client, or you would like some editorial for a publication that you produce, this is a free service that I offer to clients and non-clients, and that you can contact me at Amanda at peninsula-uk.com. I think I've just about covered it there, but anybody that's listened to me that is a Peninsula client, you know what, I do not want you sat there writing policies and procedures yourself and handling issues on your own. That is what the advice line is for, and that is what you're paying us for. So use it as often as you want. The support is there. Make sure you get on our bottom line circulation for our regular update magazine, and also editorial from our managing director Peter Doan. Also, what you can get access to is any other webinar training through the bottom line as well. I hope you've enjoyed today's webinar, and have a really good weekend, and I'll speak to you again soon. And remember, the webinar on Monday is everything you need to know about 0-hour contracts. Thank you very much, and it's goodbye from me.